Hi everyone, this is Brent Gambrell,
And Bridgette Nobbe.
and we're presenting our issue report for HED 626C, Gender and Education, on Title IX and Title VII. So just to give a brief overview of what both of those pieces of legislation are. Title IX is the amendments to the Education Act of 1972, which states that people will not be discriminated on the basis of gender in any education program or activity in which they receive federal funding. This is tied to athletics and general education services. And Title VII is amendments to the Civil Rights Act of 1974, which states that employers, including housing, cannot discriminate against people on the basis of sex, race, color, national origin, or religion. So just to give a brief timeline of the activities of what is tied in with these. In 1972, President Nixon signed Title IX into law, which again is the amendments to the Education Act. In 2016, they introduced what's known as non-binding Dear Colleague letter under the Obama administration, which included gender within the discrimination basis of Title IX. However, 1 year later in 2017, with the new administration, they've since rescinded that from the Education Acts, and furthermore, in 2017, they also pulled back from Title VII to include that gender is only a male-female issue. And then today, the Trump administration has been sought to banning transgender people from serving in the military, as well as challenging their civil rights in other arenas.
So, how is this shaped by normative perceptions? Since the 2017 rescinding of the Dear College Letter guidelines, people have held that in a strict definition in the Title IX statute, that the statute only applies to sex, which is defined as prohibiting the discrimination of individuals on the basis of sex, which means one's biological sex at the time of birth. Title VII of the Civil Rights Act of 1964 prevents discrimination based upon race, color, religion, sex, or national origin, and in 2014, rulings and memorandums from the Attorney General Eric Holder included prohibiting discrimination based on gender identity and transgender status, though this was repealed in 2017 when then Attorney General Sessions upheld that Title VII strict interpretation means enforcing a gender binary ideal. So how is Title IX seen on the University of Arizona campus? Title IX commonly contributes to access of sports and resources for students on campus. In order to follow Title IX policies, there must be an equal number of opportunities for each gender. For example, the number of student participants must be the same. The number of students in the football program is significantly higher than any other sport on campus. As a result of this, there needs to be an equal number of opportunities for women athletes. In order to accommodate this, there are more women's teams than men. However, there are an equal number of male and female athletes at each campus. In addition to the number of athletes, there also needs to be equal access for resources such as equipment, game times, and facilities. Housing is more in relation to Title VII, and at any time that there's a belief of a Title IX violation, it should be reported to the Title IX investigator on campus. This individual will use any information available to understand the case at hand and determine the response of the university. This staff should be able to make unbiased decisions free of judgment of either the perpetrator and or the victim.
So to tie this into some of the class readings that we've had and discussions within class that we've had over the past semester, this relates into the idea of heteronormativity that we saw in Pascoe's book, Dude, I'm a Fag, or You're a Fag, I'm sorry, and the idea of using all gendered restrooms or even giving people that opportunity of choice, as well as this is reinforcing that idea of the binary through the idea of dangerous masculinity. So with that, we're starting to see this idea of we can't have this mingling of genders within the restroom because boys will be boys and there are consequences in terms of sexuality from that. Furthermore, with Spade, this idea of being trans is okay as long as you're not overt about it, so that you have protections within there. But again, you have to not be out as much as some people would expect. And then finally, there's this criminalization that's placed on being other. So if you're not subscribing to the binary, you're seen as kind of outside the margins, and therefore there's this kind of criminalization, as well as any aberrant behavior there's legislation against. So, in terms of, there have been a couple of court cases recently that are possibly transforming this issue even further. First and foremost, we have RG and GR Harris Funeral Home Inc. versus the Equal Employment Opportunity Commission, and this is challenging Title VII's sex protections about gender identity. And also, there's the idea of the trans-military ban from the Trump administration, again, challenging the idea of transness and their ability to function within society. Finally, there's also Doe versus Boyertown Area School District. This is the Alliance Defense Freedom, challenging the choice of gender-neutral bathrooms and the privacy of students. This would mean that transgender students would be segregated either into their own restroom or subscribe into the gender of what they were born into. So they want, with this, also to apply or to show that Title IX policies would not include transgender protections, and it would just be based off of the individual sex, therefore pulling gender out of Title IX.
So what can we do to change the policy and practice of Title IX laws? Since Title IX is a federal law, each state and university cannot change the policies on their own to make them more inclusive. In order to make the needed changes to Title IX laws, change needs to occur at the legislative level. Universities are directly affected by the Title IX laws, and partnering with other universities within the same state and country to voice concerns and propose suggestions for change can create the momentum that is needed to move this policy in the legislative process. The Dear Colleagues letters are beneficial. However, like mentioned before, there's no legal binding behind the suggestions that are written. In order to make a lasting change, again, reform needs to occur in the legally binding policy. Specifically, the Title IX policies need to change the language to be more gender inclusive. Instead of consistently using the term sex, these laws need to be based off of gender identity and included in a non-binary format. Lastly, since our university is not one who can legally change the laws, it's our job to enforce protection of all students regardless of their gender identity.
So in conclusion, what we need to understand is the fact that the landscape is constantly changing based upon which administration is in enforcement at the time. But what we need to do is work to make sure that both pieces of legislation are inclusive and recognize that we do not live in a binary system, but rather we want to make sure that people can choose how gender is applied to them and how they wish to live their lives. Thank you.